So, are you putting your business at risk by accidentally infringing on someone else's trademark? One lawsuit can sink a startup before it even gets off the ground. So, what is trademark infringement? It means that you're using a mark that is confusingly similar to an existing trademark. And the way that you get trademark rights in the United States is through use. So if somebody else is using a name that is very similar to the one or identical to the one that you want to use, and they were using it before you were, they have what are called prior rights or senior rights in that trademark. And the trademark statute in the US protects not just that exact trademark, but any mark that would be considered confusingly similar to that previous existing trademark. And so you don't want to use a mark that is very similar to a mark that another business owner is already using, because that is when you are edging into the category of infringing on that other person's mark. So we want to make sure that you are not choosing a name that is in that category, and you want to pick a name that is unique. It really, ideally, it is fanciful and unique. That's the language that the trademark statute uses. The more unique, the more fanciful that the name is that you pick, the stronger the chances are that you'll be able to own it exclusively and you will not be infringing on somebody else's trademark. Let me tell you what the risks are of if you do engage in trademark infringement. What does it mean for you? There really are three big risks that you're facing if you are dealing with potential infringement. The first is you may receive what's called a cease and desist letter from that other mark owner. And the cease and desist letter is basically going to say that the mark you're using is confusingly similar to my mark, and you're selling very similar goods or services to mine. And because of that, you're infringing on my trademark, and I am demanding that you cease and desist. And often those letters will give you a deadline. And so you're going to have to decide, am I going to just stop using that name and rebrand, or am I going to fight this? If you decide to fight it, then the second risk that you're facing with infringement is expensive litigation. And here's the thing. If you want to fight for the mark and you don't want to back down if you get a cease and desist letter, then even if it turns out that you maybe even have senior rights in that name, so maybe it's a dispute between two mark owners, but this other person believes that you're infringing on their mark, they can cause you to incur massive amounts of legal fees just to defend yourself. Even if at the end of the day you might win that lawsuit, you are going to spend six figures in legal fees minimum to defend yourself. That is a massive, obviously, liability for your business and for you personally. And the third risk of dealing with infringement is that you could end up in a situation where you are forced to rebrand your business. And that might come as a result of the cease and desist letter, or it might come as a result of that expensive litigation. And it could come in that litigation in two forms. One would be you ultimately settle the case and agree to rebrand, or the case goes all the way to trial and you are forced by a court to rebrand because you've got an injunction against you. You don't want to risk any of those things. Those are expensive distractions from you building a successful business. And so one of the best things you can do as a business owner from the very start is make sure that you are using a brand that is unique and fanciful and that is not potentially infringing on an existing trademark. Here are three ways that you can avoid trademark infringement. One is, and I can't stress this enough, hire an experienced trademark lawyer to help you run what is called a clearance search. And a clearance search is detailed research that analyzes the other marks that are out there to see if there are marks that are potentially confusing and similar to the mark that you want to use. And an experienced trademark lawyer is going to be able to analyze what they find and tell you what the likelihood is that you're going to get either a refusal from the United States Patent and Trademark Office or approval. You doing a search on the USPTO database by yourself is always a great place to start, but it is not enough. And you do not have the experience or ability to analyze the other marks that are out there to see how similar your mark is to those and what the risks are that you're facing, both infringement against a third party and a refusal from the USPTO. These are the two things that we're concerned about as trademark lawyers when we're doing our clearance searches. So you've got to hire an experienced trademark lawyer to do that search for you before you file a trademark application, because we don't want you to file a trademark application that has no chance of approval. That is a waste of your money. And so if it turns out that we find that your mark is potentially going to be considered infringing on an existing trademark, then you can focus on a controlled rebrand, not one that you're forced to do, but one that you control, and you can do it in your own timing. And if you work with your trademark lawyer in that process, they can help you make sure that whatever brand name you do come up with is one that you can own exclusively. So get a trademark lawyer involved as early in the process as you possibly can. And one other way for you to be sure, the third way to be sure that you aren't infringing, is avoid sound-alike names or look-alike names. Often I have clients come to me. I had one just this last week that said, well, isn't it enough if there's a space? So I'm using a space between these two words and that other mark doesn't. The other mark has the words together, so it's one word. Isn't that enough of a difference so that my mark is different? And I had to explain to my client, no, that's under the trademark rules, that's the same mark. The space does not make any difference whatsoever because it looks almost identical. The words are identical. It sounds identical when you say it out loud. And so consumers are not going to necessarily be able to tell the difference. And that's really the thing that the USPTO is looking for, and courts. Are consumers going to be confused and do business with the wrong company because they thought one brand was a different brand? It's really important for you to not use look-alike or sound-alike names. That is going to get you into trouble the fastest. You don't want to use just descriptive words on the end of the mark. So say you want to use the same first word of a mark that's a competitor, but you're going to use a second word, like say the first word is like my law firm, Leverage Legal Group. Well, maybe someone else wants to say, well, I won't use Leverage Legal Group. I'll use Leverage Legal Services. Well, that word services is descriptive. Group is descriptive. When examiner at the trademark office looks at your application, they're going to see leverage legal and say, no, those marks are basically identical. They don't care about that third word. It is not going to make a difference. So adding descriptive words to your mark that is otherwise a look-alike or sound-alike is not going to save your mark. Neither will punctuation, capitalization, or spaces. Avoid those things and make sure you have a good trademark lawyer helping you do your search, advising you as you are coming up with your brand, and then making sure that you do not use sound-alike or look-alike words, and you're going to be in good shape. To avoid costly infringement mistakes, I really encourage you to just set up a call with me. Let's look at your specific brand and make sure you're not facing a risk of infringing on a third party's rights or a risk of refusal from the USPTO. And let's make sure that the brand you're using is one that you can own exclusively so that you can have ongoing peace of mind and you can get on with the business of building your business and your revenue stream without the risk of infringement. Oh, and yes, one call can not only help you protect your brand and make sure that you can own it, but it can save you not only tens of thousands of dollars, but potentially hundreds of thousands of dollars in legal fees. So set up a call with me and let's talk.